I'd like to bring in Jameel Jaffer into the conversation, director of the Knight First Amendment Institute at Columbia University. Jameel, your reaction to the latest news and Julian Assange's freedom, and specifically, if you could talk about the impact of the High Court decision in the UK on May 20th that probably pressured as well the U.S. government to reach a deal.
Yeah, I mean, I don't know what ultimately persuaded the U.S. government to make this deal. I do think it's a great thing for press freedom that we have avoided a judicial ruling from an American court on the scope of the Espionage Act and the scope of the First Amendment, because from the beginning there has been this real concern among press freedom advocates about the possible implications of this case for journalism. The indictment charges the indictment that included multiple counts under the Espionage Act charges Julian Assange with having solicited government secrets and having published government secrets. Those are things that journalists do all the time, that news organizations need to do if they are going to play the role that we want them to play in our democracies. And so, the concern was always that if this case went to an American court would rule or might rule that the Espionage Act made that kind of activity illegal and that the First Amendment didn't protect that kind of activity. And that would have had, obviously, catastrophic implications for Julian Assange, but it would have also had catastrophic implications for press freedom more broadly. So we have avoided that possibility, and that is something worth celebrating. I guess one thing I would add, though, is I don't think this is an unmitigated victory for press freedom, because we do still have this plea agreement in which Julian Assange essentially agrees that he has spent 5 years in custody for the kinds of acts that journalists engage in, again, all the time. And while this plea agreement doesn't have the same kind of judicial sanction that a judicial opinion on the scope of the Espionage Act and the scope of the First Amendment would have, it still is a kind of political precedent. It's a precedent that some future administration could point to in bringing this kind of case again. And it's a precedent that other countries can and inevitably will point to justify their own abuses relating to press freedom. So not an unmitigated victory, but still we've averted press freedom catastrophe, I would say.
And Jameel, you heard Stella Morris Assange, Julian's wife, and also a human rights lawyer. That last clip we played where she said, "We are now seeking a pardon." Mm-hmm. What does that mean?
Well, I mean, this is on Julian Assange's record, right? There is a conviction that has a kind of formal legal status, and a pardon would vacate that conviction. In terms of the legacy of this case for press freedom, I do think it would be better if this case had never been brought in the first place. I think.
And this was a bipartisan affair from one administration to the next. They brought these charges against Julian Assange. That's true.
Although, as you know, it's a complicated story, because the Obama administration considered bringing these charges, decided against it. Because they were concerned about the implications for press freedom. The Trump administration then filed the charges.
Even though President Trump, when he was running for president, said, "I love WikiLeaks," repeatedly.
That's right. But, I think that President Trump saw the press freedom implications as a positive thing about this case. Part of the reason the Trump administration wanted to bring this case was because they saw it as an opportunity to curtail press freedom. And then the Biden administration inherited the case, but then pursued the extradition for 3 years. So yes, it's bipartisan, but it's a complicated story. My guess is that the Biden administration will be thrilled to have this case behind them. I don't think that they wanted this case to be part of their legacy in the way that the Trump administration did.
Jameel, if that is so, why did they pursue it? Even though, for instance, the Biden administration announced in 2022 that it was going to limit the use of subpoenas against the press.
Yeah, I mean, I don't think they should have pursued it, and my institute, the Knight Institute, repeatedly asked them to drop the charges. But it is also true that the Biden administration resolved this case yesterday, and I think that's, that's a sign that the Biden administration didn't want the case to be part of its legacy. I don't want to give the Biden administration too much credit here because they did require Assange to agree to plead guilty to an Espionage Act charge. And as I said, that plea agreement creates a kind of political precedent. This is the first time that the Justice Department has successfully held a publisher liable under the Espionage Act. And that is a precedent that I think will be used by future administrations, and it's a precedent that will be used by other countries as well.
Is interesting as this case begins to be resolved, and Julian Assange is a free man, though he had to plead guilty to publishing what was called illegally publishing national security information. You have Evan Gershkovich in Russia, right, who's charged with attempting to publish state secrets. There's an interesting parallel here.
Yeah, I mean, I think that, part of the concern about this case, the Assange case, is that it made it a lot more difficult for American government officials to champion press freedom in other contexts. And I think, Evan's case is one of them. There are many others in which the message of the American government in favor of press freedom is complicated by the government's own actions in this particular case.